Nevertheless, the appeals chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)(b) of the statute and may be a reason for a trial chamber to grant interim release with conditions. The appeals chamber considers that such a determination is necessarily case specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected. Second ground of appeal. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state guarantees. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and the proposed conditions of release and the proposed conditions of release and the proposed conditions of release and
Is of the appeals chamber that the pretrial chamber did not is of the appeals chamber that the pretrial chamber did not is of the appeals chamber that the pretrial chamber did not is of the appeals chamber that the pretrial chamber rather not is of the appeals chamber that the pretrial chamber rather not is of the appeals chamber that the pretrial chamber rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not is of the appeals chamber that the pretrial rather not release on conditions. The appeals chamber thus considers that the appeals chamber thus considers relevant the appeals chamber thus considers relevant the appeals chamber thus considers relevant the appeals chamber's conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected. Finally, the appeals chamber notes that the pretrial chamber reached its conclusions in relation to the risks enumerated in Article 58(1)(b) of the statute on the basis of a comprehensive assessment of the information before it. In the present case, having rejected the three grounds of appeal presented by the defense in the appeal brief, the appeals chambers unanimously confirms the impugned decision. This brings us to the end of the summary of the appeals chamber's judgment. The judgment will be notified to the parties and participants after the hearing. Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We will.